Hey there.
Hey, Leanne, how are you?
Good. How are you?
I'm very good, thank you.
Good. So this is a topic I find it comes up a fair bit, and it's usually one where there's some tension and emotions surrounding it, which is um, spousal and child support when there's a new marriage in the picture or remarriage or a new live-in partner and that sort of thing.
So let me set the stage because I find it very interesting that when I speak to people who are splitting up, and I would say about 85–90% of the time, the people that I help are people that are splitting up from their first relationship. And so when I do, I really try to impart to them what I really believe, which is that separation and divorce is not the end of somebody's life. It's just one of the many milestones in their life, no different than birth or graduating from high school or getting your first degree or getting your first job, falling in love, getting married, losing a parent. There are many, many milestones in one's life. And for some people who I speak to, they see that divorce is sort of like the very end of their life. Like there's not because of their chronological age, but because of their emotional state.
Yeah.
And when I speak to them and I try to impart to them the prophecy that life will go on. And by the way, you will be happy again. You will have love of yourself, love of your children, the love of your children. You will have the love of your family members, your friends. You'll make new friends. And wait for it, and you will find love again. And most of the time, people are like, oh my God, no, 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 I will never be with somebody else again. So that's the stage for this conversation because the people that actually are doing the right thing are not only splitting up because the first relationship wasn't a healthy one, but they're going on and finding a new relationship. And in some cases, they're remarrying, and in other cases, they're just dating, and in some cases, they're living together without necessarily being consecrated under the laws of Ontario marital laws. But whatever the circumstances are, some people go on and start new families. Sometimes they're starting a new family by actually getting pregnant and having new children. And in some cases, they are adopting children together. And in some cases, somebody actually is joining a spouse who has young children and is treating that child as their own. And so when we talk about the subject matter today, which is support obligations to first and second families, it really stems from what is otherwise a very normal journey in life, which is we grow up, we form relationships, sometimes we marry, sometimes we're common law, we have children, and then at some point it doesn't work out and we move on to another relationship where there might be new children involved. So when you think about family law in that context, family law is just really just following the normal societal life journey of a lot of people. And so let me ask you this, Leanne. Have you come across situations in your practice where there's a person that either has entitlement to support from two different partners or an obligation to pay support to two different partners?
Yes, I've had it happen more than once. I have a client right now who has a support obligation to his first wife, who he has two children with, and then he had a common law relationship after that. And interestingly, he that second relationship, she had a child already. And she did try and make a claim for child support against him, as well as spousal support. But we ended up settling it that he's paid her a certain amount of spousal support. So he had, but it, possibly he could have been on, because that happens too. You can be on the line for children that aren't biologically your children, if you are in a parental role with respect to them, and there's a legal test for that, that basically if you're acting in a parental role, you're disciplining them, you're partaking in regular activities, you're going to school meetings with them, you're basically acting in place of that parent. Can be, especially if it's a longer relationship, you can be found to be in that parental role. And I don't know if I'm freezing or Steve's freezing. So.
Well, you know what, you froze for a second, but I can hear the audio did not freeze, so keep going.
Okay.
So you were talking about the standing in the place of a parent when the child is not biologically yours.
Yes.
Now let's go back to the case that you have. So in your situation, you were representing somebody that was entitled to support from two different people, or had an obligation to pay?
He had an obligation to pay. So he was not the happiest of people, because it was, he had an obligation to pay to two different women from two different relationships that he had.
So let's let the viewers in on some of the legal doctrines, some of the legal principles. So let's start with, if you are the biological parent of a child in Canada, you have an automatic statutory obligation to support your child. Period. New paragraph. If you have a spouse, and what is the definition of spouse varies from province to province, but in Ontario, you are a legal spouse if, here's the if you have a child in common, you never shared a bedroom or a house even for one night. Just the very fact that you together created a child makes the two of you spouses under Ontario law. Number two, you're married. No children, married, with children, without children, it doesn't matter. You're married, you're a spouse. Number three, you live together under one roof for 3 years as a couple. By the way, that applies at any age, past the age of 16, and it applies to any gender, same sex, heterosexual, it doesn't matter. And so those are the thresholds to become a legal spouse. And if you are a legal spouse, it follows that there could, not will, could be a spousal support obligation. We can talk about that later. But I just wanted the viewers to understand there's child support and there's spousal support, two different bodies of law, two different on-ramps to become each one. Now, what Leanne, you said a second ago was, what happens if you end up shacking up with somebody who has a child? Well, just because you move in with somebody that has a child doesn't automatically make you a payor of support. However, there is a law that says, and by the way, just to impress people, everybody likes hearing foreign language, so let's throw some foreign language at me. In loco parentis.
Latin.
English language. Everyone loves some standing Latin. In a place of a parent. What's that?
Everyone loves a little Latin thrown in there.
For sure. Why not? Call me Suave Rico. But my point is, if you are standing in a place of a parent and then you exit that role, you could also have a support obligation, even though the child is not biologically yours. That's why some people do cohab agreements or prenups when they marry somebody with children, in order to set it out that there will be no support obligations, even though the person moving in is possibly paying the mortgage or paying the rent or whatnot. Okay, so that's the legal stuff. But let's go back now and let me ask you something. Let's talk about straight up fairness, okay? If a woman or a man has a child with one partner, and then they go on to another partner and have a child with that other partner, should the children in any way be treated differently in terms of birth order?
No, they should not. And if you have an obligation to one child, I would say morally and legally, you have an obligation to support your children. It doesn't matter if one was from a marriage that failed and one is in a marriage that is succeeding, you still have that obligation. And it's interesting because I had a case recently It's finished now. We settled it. But my client had a child, and very sadly, his wife died. And the child was 5 years old. So he had a little 5-year-old girl whose mother had died and who he was supporting. Then he went into a common law relationship with another woman and had a child with her. And then that relationship didn't work out. And she was pursuing child support from him. And he was having a hard time because he was also had the one child he was supporting. And she was only, she only had one child. She wasn't considered to be responsible for his earlier child in terms of support. So he was going to be supporting 2 children, and she was supporting one child, and they had a similar income. And he was having a difficulty, doing that. And the idea was the earlier child shouldn't be suffering because he had a subsequent child. But it's complicated when you're in that type of situation.
So again, for the benefit of the viewers, let's just focus for this IG Live on child support. Let's not get into spousal support because it's only going to make things more complicated for now.
We can do that next
child
week.
Support. What's that?
We can do that next week. Spousal support next week.
So on the subject of child support, we've got in Canada and in each province tables that set out, if you earn this, this is what you pay. If you earn this and you're in Ontario and you have one child, this is what you pay. 2 children, this is what you pay. 3 children, and so on and so forth. So these are the child support guidelines. For those that are watching, if you don't know what I'm talking about, just Google mysupportcalculator.ca. We have a question here, and I'm going to answer it in a sec. But I'm going to ask you, Leanne, look at the question, and then we'll answer it in a sec. But let me just finish this thought first. So here's the scenario. Jack and Diane. Jack and Diane had 2 children. They split up. Jack works at the Toronto District School Board, and he is in an administrative role, and he makes $50,000 a year, and he and Diane split up, and they agree that the kids will live with Diane and that he will pay the child support under the child support guidelines for 2 children. Don't quote me on the number. I'm going to make up a number just as a placeholder. On $50,000, 2 children, Jack has to pay Diane $750 a month. And that's supposed to cover food, clothing, and shelter. Okay, great. A couple years later, after they split up, Jack meets Sophie. Jack and Sophie hit it off. They love each other. They decide to get married. She's a little younger. They have 2 children. They split up. Jack is still roughly making $50,000 a year. So now does Jack pay double $750, or does Jack take the $750 and give half of it, $325, to Sophie? Or is the $750 replaced with a larger number divided by 4 children? How do we deal with this? So let me answer the question. So the first answer is right out of the gates, the judges say, you have $50,000 of income. You decided to have 4 children. You have to pay child support under the child support guidelines for each of those children. Given that they're with 2 different mothers, you pay $750 here, $750 there. Whoa! What happens if Jack can't even pay his bills because of that? And so there is an off-ramp. It's a very, very narrow off-ramp, and it's very difficult to prove. And it's called a undue hardship test. And if Jack can prove to a judge that the standard of living in each of, or at least one of those 2 houses is lower than his standard of living, a judge has the power to depart from the child support guidelines table amount of $750, and a judge could say, I'm going to make this $600 here and $400 there, or $700 here and $600 there. A judge could depart from that. Very difficult. A, you need a judge, which means you need a court case with both Diane and Sophie. So right away, that's very expensive and very complicated. Number 2, Jack's got to have low enough income, and Sophie and Diane have to have high enough income that would actually establish under the actual algebraic test that Jack's standard of living is lower than Sophie or Diane. Again, very difficult. In the last 20, 5+ years that I've been practicing law, I've had this happen. When I say have it happen, I've had many cases with parents that have multiple children with many different partners. But I've had only 3 cases where we actually met the test. Mm-hmm. And it was an extreme case where I represented, just recently, actually, just a few months ago, a man who had 9 children.
Oh my gosh.
With 4 different women.
Wow.
But what makes it unique in these cases is because if he made like $200,000 a year, we wouldn't be having the undue hardship argument. He would just pay through his ears. But it was because his income was so low that it was impossible for him to pay the full table amount to so many women. So we had to actually bring an application in court to against each of the mothers. By the way, it was actually only 3 because one of them he's living with. So he's actually on his 4th relationship and they're together. So he doesn't have a statutory obligation because they're broken up. He simply has a moral obligation as well. But that is something that we argued that he has an obligation to all the children. And under Canadian and Ontario law, the law says every child should be treated equally. So then the question becomes kind of weird. Well, hold on, equally. How do you do it equally if each mother has a different income? Because the whole nature of the child support guidelines, you didn't know this for the viewers, it does not look at the recipient's income. The recipient's income could be a lot, it could be a little, but the child support that the Jacks will pay to the Dianes and the Sophies is otherwise not considering the recipient's income. But when you get to the undue hardship test under the child support guidelines section 10, we do look at the recipient's income. In fact, we look not only at the recipient's income, we look at all the income in the recipient's household and in the payor's household. So Mr. Payor, for example, Jack, is living with somebody else, we will be looking at the collective family income in that household. And if Sophie and Diane are living with somebody else, which, by the way, doesn't have to include a new partner. It could be a parent, a sibling, a friend. If the household income is greater because other people occupied the home, that's a factor to be considered as well. Anyway, my point is, these are, bless you, these are very difficult cases. But I'm going to come back to you, Leanne, and ask you, what do you think of the morality of all of this? Like, where do the Jacks fit into all of this from a fairness standpoint?
Well, and just before I answer that, there's just a couple of things I want to comment on what you said. And one of them was when you mentioned that the recipient's income doesn't matter. Of course, that's only in situations where you're not looking at a set-off situation because the child is spending, 40% or more of the time with the other parent. In that type Correct. Of situation, the recipient's income does matter. So it's only when it's not that type of schedule arrangement. And the other thing I was going to say for the women out there who are watching this and heard what Steve said, and I guess it could be the reverse as well. But I was going to say, if you've met a guy and you decide you want to have a child with him, you may want to make sure he doesn't have a lot of previous child support obligations to multiple women, because you're going to probably find there's maybe some problems with if your relationship and he's going to have a lot of obligations, or even if your relationship succeeds, he's still going to have a lot of obligations for paying for all these different children. So, but now going to your question, Steve, about the morality of it. I mean, I'm a big believer that children didn't ask to be born. I mean, I don't, who doesn't believe that? I don't think anyone's going to say children do ask to be born, but you bring a child into this world, you're responsible for them. And so if I choose to have 8 children, or if, if you, Steve, as a man, choose to, have relationships with 7 different women and father, 25 children, with these 7 different women, then you should be responsible for them. And so morally, I don't really have a problem with the payor having to, perhaps work 3 jobs to meet their child support obligations, because I think that if you've chosen to have children, and even if it's an accident, there's, you know, you could have used some prevention there or whatever, then you should be responsible for them. And so morally, I think to me, the law is in line with what I would say is morally correct. I wanted to go back to the listener's question. And the listener had asked us, can a woman claim child support from both the biological father and the new partner? And that's a very good question, because that kind of situation, you know, does come up. And you're not allowed to double dip. I mean, you know, so, you know, the case I had that I referred to at the outset, where the woman was seeking child support, she was actually collecting child support from the biological father. And then she made an attempt to go after my client for child support as well. And so she was not allowed to do that because she was collecting child support from the biological father. But I'm going to put it back to you, Steve. If the biological father was in arrears, or, you know, say Fro was taking, the Family Responsibility Office was taking action against him for not paying, or if he was just missing and, you know, gone AWOL and no one knew where he was, you know, what happens? Or if he's only, let's say he's only paying partial amounts, he's not paying his full amount, but he's paying partially. Can the woman get child support from the second partner, who may not have been the biological father, but maybe was in a parental role or locus parentis with the child?
So the judges, fortunately, in family law, look at the specific family. And there are very general principles that really are, quite frankly, very commonsensical. But the court will actually look at the factors. So, for example, they'll look at the multiple sources of income in the family. They'll look at the recipient's income, the payer's income, payer number two's income. They'll look at all the entire constellation of incomes of everybody. They will look at the children's needs. They will look at their historical standard of living, the accustomed standard of living of the children, both when they were with both the parents and then apart. So the courts will generally try to find a conclusion that really is child-centric. So going back to your question, Leanne, my experience has been that where, you know, just to use the Jack and the Diane example, when Jack and Diane split up, and Jack is paying Diane $750 a month, and then Diane meets somebody else who moves in with her, no children. Let's call him Bobby. Bobby and Diane live together for 5 years. Bobby contributes to the cost of living while living with Diane. Bobby also treats the kids as though they are his kids too. They call Bobby Bobby. They call Jack Daddy. But for the most part, Bobby and Diane are a family unit with the other two. Bobby's just not the biological father, but in every other respect, he treats these little two as though they are his own. And more importantly, Bobby does it, you know, has a fairly good income. And with his fairly good income, he covers a lot of the expenses. He pays the rent, he buys most of the groceries, he takes care of the transportation, the car, the travel, and so forth. Then Bobby and Diane break up. And then all along, Jack is paying Diane $750 a month. So the question really isn't, does Jack stop paying $750 a month? The question is, what does Diane get from Bobby? And if Bobby, on his income, would normally pay $1,200 a month, there's a very good chance that a judge is going to say, Bobby, you owe Diane $1,200 a month. And it may be because Bobby is not a biological father and he fits into the in loco parentis category, that a judge will exercise discretion and lower the amount from the full table amount. But make no mistake, the judge starts from, the first question is, was he in loco parentis? Second question, did Diane rely on Bobby's financial support when they were together? And thirdly, if Bobby does not pay, will this in any way affect the kids? And if that test is met, then the judge is going to say, okay, now we get into quantification. What's the amount? Well, the judge isn't going to pull a number out of the air. The judge is going to start with looking at Bobby's income and looking up the table amount for 2 children. If the table amount for 2 children is $1,200, we know that the high water mark is $1,200. The question then becomes, it's somewhere between 0 and $1,200. It's not going to be more than $1,200. It's going to be $1,200 at the max, and it might end up being $750. It might be $850. It might be $300. But the point of the matter is, there is a legal analysis that goes into this that is very much customized and specific to this particular family, mainly to ensure that these 2 little children are not in any way prejudiced by the various partners that their mother had.
Yeah, and as you said, it's child focused. It's all about the children, and you can rest assured that Bobby in that situation, might not be too happy with his ex-girlfriend about it, but it's not about, or he may be okay with paying child support if if he loves to the children and feels like he was in a parental role, he may be okay with doing that. And again, it really is very fact specific in those types of situations. The other one that I see come up a lot is, I'll have a client who's paying child support, and I'm going to say ex-wife. I mean, it could be the other way around. And more, I'm starting to see situations where the woman is the one having to pay support, but, traditionally it more often has been the man. So I'm going to go with that for this example. So a situation where the man is paying child support and the woman has remarried and her new husband makes significantly more money than her first husband, and he'll come to me and he'll want to know if he can reduce his child support payments because the children are already living a much higher lifestyle than him with the new man in the home. And again, it goes back to those child support guidelines and what his income is, and the fact that I tell him the fact that she's remarried and is with this new partner, it doesn't erase your child support obligation, and it's going to be what it is. And focus on the children, and that it's for their benefit, and why not have them have as nice a lifestyle as possible. But I'm wondering if that situation comes up with you, Steve, as well, because as I say, that's a question I've been asked quite a number of times.
Well, what definitely is a big trend is this movement towards shared parenting. And like you said a few minutes ago, when you correctly pointed out that the table amount isn't presumptive if the kids are with each parent nearly 50% of the time. And now we get into the calculation of the set off of child support based on the income of both parents. So given that there is this sort of movement towards shared parenting, and therefore set off child support, this is where things get really complicated when it comes to second families, because it may very well be that the children from the first relationship go back and forth, meaning 50-50, and then the children from the second relationship don't. And the judges are, really struggling to figure out what to do with that, because really at the end of the day, they're trying to do right by the children, and they're not going to allow the parents who have made choices to enter and exit relationships to in any way prejudice the children. But back to your question, Leanne, my point is that once we get into the murkier waters of multiple relationships, and by the way, we only talked about second families. What about third families, right?
Yeah.
And we touched a little bit upon in loco parentis, where you treat a child as your own. But there's a lot of families that 2 people come together. One of them had children from a previous relationship, and then they have a child together. So they've got an adoptive child, in other words, a stepfather or stepmother to a child, plus a biological child in that family. And most definitely, the stepchild and the bio child will be treated equally. There's no question. They're not going to be paying child support for one and not for the other one if they were to split up. But my point of it all is to say, I'm so glad we talked about this, because the more I talk about it, the more I'm confusing myself about how confusing the subject matter can possibly be. And we didn't even get into spousal support.
No, exactly. I mean, we could talk about this subject forever and still be confused.
So some of the remedies, really, the takeaways for our listeners are this. Enter and exit relationships with your eyes wide open, and recognize that the decision to be with somebody carries with it economic responsibilities and economic entitlements. And if you are exiting or entering a relationship, and if there happens to be children, either that you are leaving from or going to, it would probably be a good idea to spend a couple bucks and getting some legal advice and finding out what will happen if. And there's a whole bunch of ifs, and we covered a bunch of them today. Ask the questions, get an understanding so that as you go into this relationship, and maybe you never leave it, but should you leave that relationship, you have some handle on what your economic entitlement is and what your economic obligation is.
Yeah, well said. So thanks again, Steve. See you next week. And thanks to our listeners for tuning in.
Thank you. Take care.
Bye.
Bye.